Have an IRA or 401k? How the Secure Act will change your estate planning. My man Craig had emailed this to me earlier today, or a few days ago, and I thought this would be interesting to look at because I do think the Secure Act will become law ultimately, and it'll be interesting to see how the sausage making is conducted once it reaches the conference committee in the House and Senate, but. Let's see what our man Leon Lebrecq has to say. He writes about retirement, and he's passionate about pensions, recessions, IRAs, and retirement. Okay, that's a weird thing to be passionate about. You're passionate about recessions, are you? The Secure Act of 2019, which passed the House 417-3, will now likely pass the Senate by unanimous consent. It will probably change your estate planning. Under the previous rules, we could stretch IRA distributions to non-spouse beneficiaries, which allowed for a potentially significant income tax savings to children of IRA owners. For example, in the old rules, if Millicent is the owner of $1 million IRA and leaves it to her 25-year-old granddaughter, Halsey could have stretched the distributions over her life expectancy of 57 years. Coupled with the fact that inherited IRAs are subject to the claims of the beneficiary's creditors, many IRA owners created IRA conduit trusts and other mechanisms to make sure beneficiaries could take only the required minimum distributions. And I just, look, man, unless you got something wrong with Halsey or whatever her name is, I've never understood that. I let them have the money, for heaven's sake. I don't get it. Now, look, Halsey might be sniffing up her nose. Don't let her have the money. I get that. But if you're comfortable with your kids and or grandkids, just let them have the money already. I just don't put restrictions on it. I'm telling you, that creates bad things. There are reasons to put restrictions on it, to leave your IRA to a trust, a conduit trust, what he says here, but don't use that as a default. It doesn't make sense. The Secure Act changes that paradigm. For most beneficiaries going forward, the stretch rules are eliminated and the beneficiary must withdraw the entire IRA within 10 years. So I think the Senate's 5, right? There are exceptions to the 10-year ruling, including a spouse may roll over the decedent's IRA to their own and stretch distributions over their lifetime. Well, that's not the exception. I mean, that's not non-spousal beneficiary. That is a spousal beneficiary. So a spouse can roll it into her own or his own and continue to stretch distributions over their lifetime. Okay, that's not a change. That's the way it was. Children under the age of majority. Upon attaining majority, they must then take distributions under the 10-year rule. Okay, that's interesting. So does that mean they have life expectancy beneficiaries if they're 16? And then at they're 18, they have 10 years? That's confusing as all can be. A disabled beneficiary or chronically ill beneficiary or a beneficiary within 10 years of the age of the decedent. Disabled, I didn't know. So good stuff. I'm glad I've read this. Thanks, Craig, for sending this. A disabled beneficiary or chronically ill beneficiary doesn't have to exhaust within 10 years. That's interesting. But that might be another case where you set up a trust for sure. The normal IRA estate planning strategy before Secure Act was to name the individual IRA beneficiaries and create an inherited IRA for each. The beneficiary would then take the RMD's rules based on their age, name a living trust as the beneficiary, resulted in the RMD being based on the age of the oldest living beneficiary, which was often less than ideal. A living trust needs to have a look-through provision to allow the IRA to be distributed through the trust. All right, okay, all this stuff is fine. Just a failure to name individual beneficiaries formally resulted in the imposition of the 5-year rule, which forced all IRA balances to be distributed within 5 years of the date of the IRA owner's death. Now it's 10 years. The look-through stuff isn't that difficult to establish on the IRA, leaving it to a living trust. But just keep that in mind. Regardless of what happens to the Secure Act, if you're going to establish the IRA, it's got to have these 4 provisions I'm not going to get into now. That's why you need to see legal counsel, not just LegalZoom. You need to see legal counsel on that. I've just never been a big fan of that, frankly. You still got to find who's your successor trustee, and that person really wants to take. Is that person really is going to have a duty to manage the distributions of your IRA? Does that person really want to take that obligation? More than IRAs, a 10-year rule applies to all qualified plans with balances: 401ks, 403bs, 401as, profit sharing plans, ESOPs, 457s, TSP, the whole thing. Upon their death, spouses will typically roll over their deceased spouse's plans, which build the IRA. This can generate a residual rollover IRA with a combination of all prior balances. So if Jim has $500,000 401k and rolls it to an IRA and subsequently dies, his wife Mary could add to her IRA, which would contain Mary's 401k rollover. If Mary then leaves that combined IRA to children over the age of majority, the 10-year rule will apply. Okay, well, that inherently makes sense. It's the way it's kind of always been. Not the 10-year rule, but the IRA being consolidated and then sent to this non-spouse beneficiaries. All right, so he talks about the look through things. I don't. That's fine. But under the Secure Act, distributions must be taken within a 10-year period. Determining the exact timing of the distributions of the 10-year period will be based on a variety of factors for taxable IRAs, including other income and what? With the new rules, managing the distribution for the designated beneficiaries will become very important because it must be taken within the 10-year act. Determining the exact timing of the distributions within the 10-year. Okay, I gotcha. I thought that was by law. So determining the exact timing of when to get the money to your non-spouse beneficiary under the 10-year rules, you'll need to look at other income and expenses of the beneficiary. Business's loss of a beneficiary in a pass-through entity for a subchapter S, for instance, it generates a $250,000 loss. The beneficiary or the trustee could distribute $250,000 or more to offset the loss. No, that's the loss. That's good. Charitable contributions by the beneficiary, including those through donor-advised funds. For example, if a beneficiary decided to make recurring charitable donations of $5,000 per year, they might make a $50,000 donor-advised fund donation and offset that distribution with $50,000 from the inherited IRA. Okay, that makes sense. Qualified plan contributions. If an inherited IRA beneficiary worked at a company or owned a business where they had opportunity to participate in a qualified plan, they could offset plan contributions with IRA distributions. Yeah, there you go. For example, an inherited IRA beneficiary that was a sole proprietor might use a qualified plan to reduce taxable income by as much as $63,000 in defined contribution plans and prospectively much more in cash balance or pension plans. Essentially, that might offset that contribution with an IRA distribution from the inherited IRA. Makes sense. Inherited Roth IRAs are still subject to the 10-year rule, but they get the distributions are simpler because they get to take tax-free. So in this case, inherited Roth IRA might be in a trust that distributes the total of the Roth IRA balance of the 10th year to the trust and then proceeds to sprinkle distributions to the beneficiaries from the trust. Allocation of taxable and Roth IRAs. Another strategy in adjusting estate planning will be to allocate taxable and Roth IRAs to appropriate beneficiaries. The 10-year rule will exacerbate tax discrepancies for beneficiaries. Logically, charitable bequests should be made from taxable IRAs so that high tax bracket beneficiaries can benefit from Roth legacies. Measuring after-tax equalization may be of interest to some families. All right, this is starting to bore me now because this isn't going to apply to most of us here. IRA trust, okay. They're more, including the use of life insurance. Life insurance under the new rules is complex enough to warrant a separate discussion, so stay tuned. Okay, I don't know anything about the life insurance under the new Secure Act. If an IRA or rollover from a qualified plan are part of your legacy, you probably want to dust off your estate planning binder and talk to an expert. Yeah, okay. All right, so that's interesting. What did I say right there? Okay. A lot going on there that's not going to affect most of us. So just go back to the issue, my friends. You got, $200,000 in an IRA. All right, is it worth leaving it to a trust? And the answer is no. I mean, unless there's some significant reason, i.e., disabled child, special needs kid, your kid's going to sniff it up his nose and all that. It's just not worth leaving it to a trust. I'm just telling you it's not. And the reason for that is because you have to have a trustee. That person is the person who's got to make sure and manage those distributions by law and do it right. I'm just telling you, and if you got one of the beneficiaries of this trust, your IRA, that is leaving to a living trust that now becomes irrevocable, there is a cottage industry of suing estate planning people because they screwed it up somehow. And it doesn't have to be legitimately screwed it up. It just says the beneficiary says, hey, you invested in Apple. You should have invested in Google or whatever it is. Just don't put anyone through that burden. The only time you really want to leave, and look, seek your own estate planning counsel. I get it. But if your kids are just normal kids, buy 4 kids, and you're not worried about them sniffing up their nose or freaking giving it to the communist Bolsheviks and Antifa, just freaking leave it to them. Let them take it out. If they take out too much and got to pay taxes, well, it sucks. But just, tell them and say, look, don't take this out in one lump sum. I think we get way too wrapped around the axle on some of this stuff. And as I always say, keep it simple, stupid. So the perfect example of it. But with that said, you need to know the rules because they are going to come and Trump's going to sign this for sure. So just be advised. All right, we'll see you next time.